All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We'll figure this out shortly. Good morning. Welcome to the First District Court of Appeals sitting in Pensacola. We have two cases on the docket today. We will take them in the order in which they appear. We will take about a 10-minute break after the first case before we hear the second. The first case is Universal Property and Casualty Insurance Company versus Carmo, 243259. Counsel for the appellant, you may proceed when you're ready.
May it please the court, good morning. My name is Paulo Lima. I'm here on behalf of the appellant, Universal. I'd like to reserve 4 minutes for rebuttal, please.
So noted.
Thank you. We're here because the trial court abused its discretion in denying Universal's motion for remittitor or new trial based on the fact that the jury's damages award bore no relation to the evidence that was actually presented at trial. As I said, Universal moved alternatively for remittitor or new trial. The evidence is essentially the same. The new trial argument is that the evidence that the verdict was against the manifest weight. But if we jump to the remittitor test, that might be the easiest way to analyze it. That's how the trial judge proceeded below. He looked at the statute.
Before you start on that, you made an argument that the opposition to remittitor was waived. Do I have that right?
No. Well, yes. I'm not sure I understand. It wasn't waived. They filed a response to the remittitor motion, and so it's been properly presented. The court considered it, heard argument on it. Neither side has said that the remittitor argument is waived.
Okay,
Okay.
we'll talk about that with
Certainly.
Appellant's counsel.
But jumping to the statutory factors found in section 768.745, there are 5 sub-factors, I guess, and the 2 that really are relevant here are 4.
Counsel, I'm sorry to interrupt, just to go further on Judge Winterker's question on waiver, or maybe invited error, perhaps, is another way to approach it. Below, what was the trial strategy in terms of whether or not a particular amount or amounts should be submitted to the jury in response to their question?
Well, the parties basically agreed that there was, well, I won't say they agreed, but the trial judge allowed the plaintiff to submit 2 alternative measures of damages. One was the replacement cost value with matching, and the other was an actual cash value without matching. And the plaintiffs submitted a very consistent theory throughout the case. They presented two estimates from Triad Restoration Services. So we've got the Triad RCV estimate for about $79,000 and change, and the Triad ACV estimate for about $50,000 and change. And they also put on the testimony of the general contractor as their damages expert, the man who prepared both estimates, and he testified very clearly. He stood by the numbers in those 2 estimates, and he said that those numbers were, quote, all-encompassing. That's at trial transcript page 158. And by that he meant, and he specifically said, that it included the cost to address any water damage, any damaged property that was directly damaged by the water, plus the cost to tear out the pipe system and to put the house back together in its original form. So Mr. James, the general contractor, testified this is an all-encompassing estimate. It includes soup to nuts, everything. And those were the 2 numbers that he put forth. And consistent with that, and very logically so, plaintiff's counsel during closing argument, when going through the verdict form, he gets to question number 2. He says, well, this is easy, jury. You're going to look at plaintiff's exhibits number 17 and 18, which are the 2 Triad estimates. Go to the last page. Those numbers, $79,000 and change, $50,000 and change. That's the only evidence you have on that, and that's at transcript pages 906-07. Inexplicably, the jury comes back with an award of $335,000 for the replacement cost value, which is 4 times the amount of the Triad RCV estimate.
But at one point, the jury had a question, and the question had to do with whether, to paraphrase, it should be limited to those two, the Triad estimates. And there was conversation with the judge, and I believe it was your client's position that, no, the jury can come up with its own number, and that they're not limited to those two estimates. And so does that position at trial reconcile or conflict with your position on appeal?
It does not, Your Honor, and I was searching through my notes here and I found it. The jury's question was, quote, do we complete the numbers for both A and B, blanks, on the verdict form, and are those numbers obtained from Triad's estimate? Now, plaintiff's counsel said we should say yes. There was a colloquy with counsel outside the presence of the jury. And then defense counsel came back and said, well, no, not necessarily. The jury can look at the Triad estimates and award some amount less than that if the jury concludes that, well, we don't think all of the evidence supports the full amount of the Triad estimate. But the
what
crucial
evidence was in the record that would support anything less than the Triad amounts?
Well, the evidence that was put on by Universal was from the expert plumber who said that these pipes don't need to be replaced.
Right, so that's nothing, right? So I see it's either, no damages or the Triad estimates. What evidence exists in the record that something less than the Triad evidence, if in fact there was to be coverage, would support anything less than those estimates?
Well, the Triad estimate was to replace the entirety of the drainage system. And during cross-examination of plaintiff's witnesses, defense counsel elicited, and I'm sorry I can't point to any particular particular testimony, but the theme was essentially that, to the extent that there needs to be some replacement of the pipes, it's not the entire system, that there are spot fixes that may be able to be done. But frankly, I think that is a secondary issue because, again, the crucial statement by defense counsel during that colloquy was that the decision, quote, has to be their decision alone, based on the evidence that they have. And we've cited that at record page or transcript page 956. So at all times, never did Universal's counsel say the jury can just come up with whatever number, and certainly not a number that's 4 to 6 times the amount of the Triad estimate. And again, getting back to
I don't think that's the claim, though. The claim is that defense counsel said that they're not limited to the amounts in the Triad estimate, which is arguably, as Judge Ray suggested, inconsistent with your argument against remediator.
Well, and I think that I'll take issue with the phrasing there, not limited to at least what the intention, I think, is that the jury does not have to award the amounts of the exact amounts of the Triad estimate. They don't have to award $79,000 and change or $50,000 and change. But the ultimate position, and I think as stated very clearly, is that whatever they award, it has to be based on the evidence that they have. And that's consistent with the case law that we've cited here, because sort of the biggest overarching principle in this case here is this is not a personal injury case where we're trying to evaluate the extent of someone's pain and suffering, which of course there's reams of case law that says that's inherently difficult to measure or gauge, and that's uniquely within the jury's province to determine how much someone's pain and suffering is worth. These are economic damages, and I don't want to cite a bunch of case law here. It's certainly in our briefs, but the principle is that the plaintiff in an economic damages case has to put on evidence that supports an award of damages in a definite amount.
Okay, and that's where I still have some concern with the position below that the jury could come up with an amount other than the Triad estimates, and your position now on appeal that the jury can only come up with the amounts that were presented in the evidence. Then the only evidence that we have on specific dollar amounts are the Triad estimates, correct?
Correct. That is the only estimate of specific dollar amounts. But I think the question here for remediator purposes, however, is was the jury's award, $335,000 RCV, $305,000 ACV, was that number supported by any evidence? And as we've gone through in the briefing, the plaintiff has come up with a number of different sort of alternative theories to try and explain how the jury arrived at such a large award. And again, I have to keep trying to get back to the trial judge's statement below where he says, quote, "I didn't know how they came up with that amount either." That's at the hearing on the new trial motion. And then about a month later at the remittitor hearing, the judge said again, "I was surprised when I got the verdict. I didn't know how the jury came up with that amount."
What
So
number other than the triad estimates would have been supported by the evidence?
I think any number, without having the estimates here in front of me, those are line items estimates. So to the extent that the jury could have looked at it and said, well, look, I see this amount is for water damage, this amount is for tear out. Certainly they could have awarded and by tear out I mean the cost to dig up the pipes and then put the house back together. Those are distinct amounts, and there was actually testimony below that said the amount of water damage, Mr. James, their general contractor, he said the amount of direct water damage within the house was somewhere along the lines of $12,000 to $14,000. So the jury certainly could have said, you know what, we're going to give them the water damage, but we don't think that there is any tear out required here. We're going to agree with Universal's expert who says the pipes just need to be cleaned. So plaintiff, you get the $12,000 to $14,000 in water damage. We agree Universal underpaid for that. However, we're not going to give you the amount of the tear out. So that would have been supported by the evidence.
There was a lot of discussion about the 2-foot wide trench, right, and the tear out of that to replace, I guess, the leaking pipe. Why would it have been unreasonable for the jury to conclude that more than a 2-foot wide trench was necessary to tear out and replace?
Well, there's a number of things to say about that. Number one, the testimony is that these are 2 to 3 inch wide pipes. Mr. Jaremko, the plaintiff's expert plumber, his testimony was that he detected moisture, quote, close to the drain lines and, quote, a little further away from it. There's no testimony that says the entire floor throughout the house was moist. That's number one. So number two, and more importantly, I think, again, keeping in mind the law of economic damages, is that nobody ever quantified the amount of additional slab, let's say, that may need to be pulled up, nor, for that matter, did they ever say how much it was going to cost. This is a jury of 6 lay people, and to suggest that they would be able to come up with their own calculations as to how much it would cost to tear up floors in these 5 rooms but not these 3 rooms without any expert testimony is just not plausible, frankly. That the only way that they could arrive at those numbers is by speculation and conjecture. There's just no evidence to support that. Another theory that the plaintiff has put forth that we haven't discussed yet is sort of what I call their inflation argument. Again, the problem there is that not a single witness came forward and testified that prices have gone up significantly. Now, Mr. James did testify, Mr. James, their damages expert, the general contractor, that this estimate was prepared using 2019 prices because the date of loss was in 2019, and the software that they used to prepare these estimates automatically import prices from a geographic region and the time relevant to the loss. So the trial's in September of 2024. He says these are December 2019 prices, but he certainly never said, oh, and by the way, since then, prices have gone up. Never even said that, much less did he say they've gone up by 400%.
So what's the point in instructing a jury that they can use their common sense in evaluating damages, if not to allow them to use common sense that there could be inflation at risk here? And then my question, though, I'm not suggesting that, from $70,000 to $300,000 would compensate for inflation, but what if it was a $90,000 damages verdict? Would you still be here asking for a remittiture under your theory?
It would be a closer call, but I think that there would still need to be some testimony. Again, if Mr. James had testified that, yes, there has been a significant increase in prices, and I'm going to say it's been between 30 to 50%, the jury could then use its common sense to either accept that or reject that. And I think that's what's meant, because I think the defense could have stood up and said 30 to 50%. That's a ridiculously high number, and you've heard from the defense expert over here that says it's a 10% increase. And so certainly the jurors are not asked to abandon their common sense. But at the same time, and that's what the trial judge and the plaintiff have put a lot of stock in. Common sense, the jury was asked to award what they think would fairly and adequately compensate the plaintiff. And that really was the trial judge's stated basis for denying the remittitor. He says, well, if I'm going to step up and grant a remittitor, I'm intruding on the jury's province, essentially. But that's not true, because if you look closely at the actual instruction that was given, and you look at the, and I'm searching for it here, and if you look at the standard jury instruction on damages, what the jury was instructed is that it should, quote, award her an amount of money that plaintiff proved by the greater weight of the evidence will fairly and adequately compensate her. It's not award what you think will fairly and adequately compensate her, never mind what the evidence shows. The jury was certainly allowed to employ its common sense in evaluating the credibility of the witnesses who testified, in evaluating the detail. And here, there's no criticism of that. Mr. James was very, very detailed in his testimony. He stuck to the amounts that were in both of his estimates, the RCV estimate and the ACV estimate, and he testified consistently with that represents the full cost to put the plaintiff's house essentially right back in the shape that it was in prior to the loss. And again, that's what the plaintiff's attorney asked for in closing, logically so, award the amount that my expert has testified to, the amount that's in his very detailed estimates. And again, somehow the jury came back with this number that is 400 to 600% more than the amount of those estimates. I think at this point, unless the court has any specific questions, I'll yield the balance of my time and reserve it for rebuttal.
Thank you.
Thank you.
Good morning. Mark Nation on behalf of the FLE. May it please the court. I want to clear up a couple of misstatement of the facts first, and I've kept track of your questions. I will deal with those. The estimate, the triad estimate, is for tear out only, not water damage. It did not include water damage. It was simply a 2-foot trench through the entire system. And we proved that the entire system itself had holes in it and sewage was escaping from that. That's and if you look at, I think it's page 1115, there's a drawing of the house with dimensions. The pipe goes all the way through the house from, if we're facing the house, from the left to the right, from the right to the left, at the back of the house, and then comes through the house towards the street.
So,
Yes, sir.
I'm sorry, if the triad estimate was only for tear-out damages, what evidence was there of the amount that could have been given for water damage?
Yes, sir. There is a lot of evidence. And if you look in the PuraClean documents that are in evidence, and they were in the policy period, they came out and it took them 11 days to just dry it. Not remediate any of it, just to dry it. Their photographs, and I would encourage you to look at page 679. It's in the middle of the 74 pages of photographs. They pulled up the floor, completely black with sewage everywhere. In every one of the photos, when they pull up the floor, black with sewage. That is, the only evidence is that it is from this pipe. The moisture meter readings that PuraClean did throughout the house confirm that that's inside the slab.
So to the extent there's evidence that there may have been a greater scope of damage, what evidence was in the record as to the cost to remediate that damage?
Great question. And I suspect what happened is, and I'll answer that this way, they looked and saw, can I make one more point about the extent of the water damage? Mr. Jaremko's photographs, and all the photographs, PuraClean's and Jaremko's of the moisture meter readings, give a location and then a close-up. So we know where they are in the house. But at trial, there was a demonstrative board with those photographs with Mr. Jaremko, and I went through with him where those photographs were in relation to the pipes. Some of them were far off the pipe, not a few inches, nothing small, very far off the pipes. And the jury saw that, and Judge Brown saw that too. As to the cost, that dimensional drawing by Mr. James gives us the sizes of the rooms, and then a jury could easily say, well, for 2 feet of getting that slab out and the things that are on top of it, it costs this much per foot. That's an easy math problem. And they said, well, we see these damages throughout the house. Come up with a number that way, apply inflation to it. They don't have to be mathematically perfect. Somebody could disagree with it, but I suspect that's what they did because that's what the evidence was there that was available to them.
Let's do the math here. So the 2-foot dredge, what was the evidence as to the cost, the dollar cost for that?
Say $80,000.
$80,000, and
for the
then,
RCB.
right, but isn't it some speculation, at least some guesswork as to how they got from 80,000 to over 300,000?
I don't know if we can put ourselves in their shoes and become a 7th juror to do that, but there is at least a basis for them to do that. It's $80,000 for the 2-foot trench, back out through the rest of the house that has the sewage damage. Go from the 2019 pricing to 2024 because it's reflected in the APT contract that's in evidence. That's what they're going to have to do the work, and then they come up with their number.
You know, the trial judge ultimately denied the motion for remittiture, but
Yes,
he
ma'am.
did express concern about how the jury came up with that verdict, and on several of the factors expressed concern about, what evidence was in the record. And under the abuse of discretion standard, I understand what the ultimate ruling was, but what do we do about that expressed concern? Or do we take that into account?
Absolutely, and I would, and it was 2 factors, but the 2, D and E, the 2 factors are very related, and they're exactly what we're talking about here. He then ruled in our favor based on the jury instruction that was given, and they agreed to, and we'll get to what I think is their stipulation that the jury can do whatever they want. And he based it on the evidence that he saw. There was moisture meter readings, the extent of and these aren't little holes in that pipe, they're all over, and the testimony from Mr. Jaremko that it goes up, down, left, right, but gets sucked right into the slab throughout the house.
How should we understand the triad estimates to the extent that they have prices for a variety of different rooms? I mean, kitchen, family room,
Yep.
laundry room. So are you telling us that that's not work done on all these rooms?
It is for the 2-foot trench only. So if I have a 2-foot trench here, there's a cost to move this, say, cabinet out of the way to get to that. But it raises also a good point. It is only an estimate. And he talked about it, an estimating software program, Xactimate. Another thing that a juror could easily do from their life's experience is that $79,000 to go all the way through this house, that is an estimate. How many of us have gotten a bathroom redone? And in our real life experience, they could easily say, that's not reality. That is simply an estimate.
So that's a juror basically reaching a verdict based on their own personal experience, not on the evidence, right?
I think it's their background and their experience that they're told to use. And and I'll reverse it. If I said it's some extraordinary amount for that 2-foot trench, the jurors would absolutely be able to go, no, I've done that, I've had estimates for that, we've all done work on our house, that is not based in reality.
But wouldn't it be the adversarial party's obligation to put evidence that would be closer to reality?
That would
And
be,
not the jurors' prerogative to just sort of use their own personal experience to come up with whatever numbers they want.
and that's what they said, they can come up with whatever number they want. And they said, you apply the broad evidence rule. I added, as a concession, and I don't know if that was the first question that you were talking about, it said, we should just tell them that, if you want to, as a concession. They said no. They can do whatever they want.
Well, before we get to that, counsel, when I read the trial court's order where he denied the motion, he basically suggested that there was a dispute, a contradiction between the jury instruction and the statute. And what he chose was, I'm going to go with the jury instruction. The jury instruction says that we're telling the jury to use their common sense. I'm going to go with that instruction because I think it conflicts with the remediator statute. Is that the right way? If there's a conflict between a jury instruction and the statute, should we go with the jury instruction?
No, and I don't know that I don't remember the exact words you used, but I would suggest there is a tension, though. Because
Well, even if there's a tension, which one?
yeah, I think
Even if
you-
there's a tension,
it-
I mean, maybe you
you-
probably guessed it by the way I'm asking this. Isn't the statute the law?
Yeah.
A jury instruction isn't the law. That's just what, we just wrote an opinion about this. It's just what it's not a Supreme Court rule. It's just what a civil instructions committee comes up with for how to instruct a jury. It's not the law at all.
Well-
If there is a conflict with the statute, shouldn't we just say, well, then I guess the jury instruction needs to be ignored in favor of the statute?
No, I think it should be probably a balancing test, looking at all the evidence. And I don't think we can say Judge Brown didn't look at the evidence in reaching his conclusion. He's looking at both of them and putting ourselves into their shoes. We've now become the seventh juror when there is evidence in there that supports a higher number. I don't think there's any doubt about that. Supports a higher number. Now we look at what is that evidence? Is that result that they came up with the same that this panel would come up with on those? Maybe, maybe not, probably not. But it's not so unreasonable that it would be an abuse of discretion by Judge Brown to say, I saw the trial and they were told what the jury instruction said, that's what they found was reasonable. Ultimately, isn't that his ruling that he's not saying it's unreasonable, he just had questions about it. Let me see if there was anything else.
Well, I would like to get back to
Yes, sir.
the jury question and the discussion that followed. It seems like when the motion for remediator was made, that you suggested that, well, they essentially waived this, they invited any error by refusing to agree that the damages should be limited.
Yeah.
So do you consider, is that a waiver? Are you
I
saying that
think
they
it
waived
is.
the motion?
During the discussion, I had a feeling where this was going. So, as a concession, I would have said, do that. They didn't want to concede. They wanted to say, no, it should be less. And would they be in here now saying, well, the jury can't come up with something less?
So they had no right to make a remediator argument at all because of what they said during the discussion regarding the jury question?
Not on these facts, I don't believe so. And if they'd have come back at some
Sure,
astronomical number.
Right,
then
exactly.
I
They come
get
back
that.
with $1 billion, then they
Yeah.
would be permitted to.
No, I would not be arguing they had waived that. I
But
think
they waived it
that would be a
because it
due
was only
process issue,
330?
probably. What's that?
They waived it because it was only 300? That's not a waiver, but $1 billion would be a waiver.
Yeah, I don't know if I called it a waiver more than pointing out that the sort of an invited error. It's somewhere in there. I'm not saying it's totally waived, but they were given the opportunity to prevent this themselves. And they chose not to. They repeatedly said they can give whatever they want. And they repeatedly relied on the broad evidence rule, which gives, you don't have to have any exactitude. It's just a tool that the jury can use. So I don't know if that answers that.
Thanks.
Another
Yes,
piece
sir.
of evidence is the APT contract. And our understanding is that the APT contract redacted all of the values in there.
It did.
So how does that contract support an award of damages in this case?
The most important component of that is the fact that it has to be, the pricing has to be renegotiated whenever the work's going to get done. And so that's before the jury. They saw that. And they knew everything was 2019 pricing. That was a early 2020 contract. And so that, I think, is one of the factors that led to this. I think any reasonable jury seeing that contract knowing it's 2024, knowing what's happened to pricing since 2019, would take that into account.
The challenge still remains that the jury had no evidence to establish what new values might be, how much products or labor would increase over that period of time, and unless there is something in there that I've overlooked.
No, there's nothing, but I would, and I cited all the cases that talk about inflation. They don't have to have that. When we have a PI case and we're talking about the reducing to present value, we give that without any expert opinion. They're allowed to make that determination, reducing medical prices at maybe 30, 40, 50, 60 years in the future to present value. And so in doing that, they apply medical inflation on their own with no guidance whatsoever, and the case law is clear on that. And then they apply what the plaintiff will earn on that money over that same period of time and reduce it to present value. And we task them with that. It's happening throughout the state this week. And there's never any question about it. Why couldn't they do the same thing? They have much more ability to do it in this circumstance than they do in that one. And so I think they're allowed to look at the magnitude of the damage, the fact that it's 4 or 5 years later, and also looking at all the evidence about where the water went. And I would encourage you to look at those photos. It's sewage throughout the slab.
What's your best case that holds economic damages, based on past occurrences, can be extrapolated in the ways you're suggesting?
This is, I've cited them, all of the broad evidence cases. I think those are actually all very good for us in this section I have on broad evidence rule, that it is up to them. They can determine what's reasonable, accept or reject any of the opinions they want. And I list all of the things in each one of those cases that the courts have said they can rely on. And mostly it's their own experiences to come up with those numbers. I don't have a best case, because every one of those broad evidence rule cases deals with that. And several deal with the inflation aspect of it. I appreciate your time. Wish y'all had a little warmer weather up here.
It's colder in Tallahassee, so it's
Yes.
fine here. Thank you, Council.
Thank you.
I want to hit a couple of points that council made. Number one, he talked about the scope of the triad estimates and said it was for tear out only. I would cite the court to transcript page 158, where Mr. James, who prepared the estimate, is testifying. He says, quote, "It's inclusive of the tear out costs to replace the draining system. It also includes any water damages that we documented at the inspection, so it's kind of all encompassing." So the triad estimate clearly encompassed all of the work. Another point that I would want to make, there's been some discussion about inflation and the APT contract, and the jury could sort of extrapolate from that. A point that was made below by defense trial counsel at one of the hearings is that it would be improper to apply 2024 pricing anyway, because the measure of damages is, in a breach of contract case, is the value at the time of the breach, not at the time of trial. Counsel below cited to the Jeremy Stewart case out of this court, and also most recently, Biletti versus Universal is a decision of this court from October that holds the same thing. And so this business about inflation being a justification is not supported legally. And to the extent that counsel wanted to rely on the APT contract, the contract does say that APT reserved the right to increase the price if the contract weren't executed within 60 days. It could increase to account for increases in labor and prices and that kind of thing. However, it also expressly states that that in order for there to be some sort of an increase, that there would have to be the submission of evidence to document those market increases. That never happened. The plaintiff never signed the APT contract. None of that ever happened. And so that's not a basis for the jury to look at and just sort of do their own work and come up with this number. A lot of discussion also about the scope of the water damage, that there could have been additional moisture in other parts of the house. But again, I think, Judge Ray, you hit it on the head, that there was no evidence from which a lay jury could come up with a very technical estimate, I think. I mean, I don't think any of us here is in a position to determine how much it would cost additionally to rip up other rooms in a house that are not accounted for in the estimate of a general contractor. I mean, that was his job. That's what he said he did. He prepared 2 estimates, very comprehensive ones, that took into account the price to do all of the work. And as for the jury extrapolating and sort of doing math and going into the jury room with a calculator and trying to mathematically come up with their own version, that's just not what the case law on economic damages allows. It is the plaintiff's burden to put on evidence that allows the jury that shows in a definite amount the amount of economic damages that they're seeking.
Is it your position that the broad evidence rule would not apply when the issue is solely one of economic damages? And I think even trial counsel below relied on the broad evidence rule. So I'm trying to understand what are the limiting principles of that rule for an economic damages case.
The broad evidence rule, Your Honor, does apply to economic damages. But if you look at the broad evidence case law, and we've made this argument in our reply brief, probably much better than I'm going to articulate it here, but the purpose of it is to allow the jury or the plaintiff to put on other evidence that shows other metrics of valuing the loss. The classic example is, here's the resale value of this particular piece of property, when the relevant metric is actual cash value. So you're allowed to look at sort of other ways of valuing the loss. That's not what we have here. What we have here, the plaintiff put on direct evidence of the actual cash value. So there's no need to go looking at sort of other metrics of evaluating the loss. What he's talking about here is allowing the jury to look at just other random testimony that sort of tangentially may apply to damages and say, well, I'm going to inflate the actual cash value award by some wild amount of 400 to 600%. So the broad evidence rule has no application here. I see my time is coming to an end unless the court has any specific questions, which I'll be happy to answer. I'd ask that the court reverse and remand for a remittitor or a new trial.
Thank you, counsel. Thank you to both attorneys. We appreciate the arguments today. The court will stand in a brief recess and allow the next counsel for the next case to approach, and then we'll take a little break. Thank you.
All rise.